Let's bring in our guest now to discuss. Joining us this hour, National Trial Attorney Michael Jaafar. Michael, thank you for joining us both. So first of all, I have to say a brilliant way for the defense to end by saying, the state, the Commonwealth just made my point. It's a difference of opinion. That's a jury issue. Weigh in. Do you think this expert should be allowed to testify?
I hate to agree with the defense on this, but I think he should be allowed to testify. My hatred for Karen Read aside, I do believe in the letter of the law. I think that this, because look, the prosecution's argument is, hey, he just wants to have these salacious comments and have us knock it down. Yeah, that's kind of the point, right? I hate that I feel like I'm defending Karen Read. I'm not, but I believe in the process. I want, if she gets convicted in the second trial, I want it to be done the right way. I don't want there to be an expert to be excluded. In my opinion, he's clearly an expert, and if there's a difference of opinion, that's the whole point of being having a battle of the experts. So I do think he should be allowed to testify.
Yeah, good point. Our good friend Don Owens, avid watcher of court TV, has a good idea. He can't, I can't get my head around how we don't know whether or not this was done at 2:30 or 6:30. It just seems as though there has to be an agreed upon answer to this. And, he says do the old scientific method, reproduce it. Go have someone do the exact same search as Jen McCabe did, then keep the browser open, do it again at 6:30 in the morning. But are you surprised, Michael, that in this day and age with technology that there's not a clear answer? Was this search done at 2:30 a.m. or 6:30 a.m.?
You know what? People will be surprised when they find out that you actually don't know. Like the way things ping off towers, the way routers work, it's not an exact science. It's not a precise science, especially when you're looking at something like a murder trial. It would be great if you have like the raw metadata of somebody's actual phone and you look at it. Sometimes you can have some really compelling, reliable evidence of when it happened. The only reliable way electronically is to look at the time somebody's phone sent a text message, not even received a text message, but sent a text message. Google searches are completely different. They're kind of like still the Wild West. But I agree with you. It should be, but it just isn't. And by the way, in this case, 4 hours is everything.
Yeah, absolutely.
That's why they're fighting so hard. This is important.
This is very important to both sides. I just have to ask you, how do you feel when you argue a motion, Michael, and the judge takes it under advisement? Because I remember I would do it if I wanted to go back and review the law again, make certain the law clerk looked at everything, just reconsider, sleep on it. But as an attorney, how does it make you feel?
Well, sometimes you lay awake and I say, maybe this judge won't make a decision for 7 months. Right? Sometimes you're nervous about it. Yeah. Sometimes, but in criminal cases, they make decisions quickly. I always like it when judges want to ponder on decisions, because at the end of the day, as lawyers, we all know judges. They used to be lawyers, right? They went to law school with us. We all know that they're human beings. They have law clerks. They want to research stuff. And so to answer your question, Judge Ashley, I always like it when you know that the law clerk is a well-read law clerk and you feel confident in the law. There's been many arguments you make when you're not confident and you hope that the judge makes a quick decision, and when the judge wants to take it under advisement, you think, man, they're going to take it under advisement. They got a great law clerk. They're going to rule against me. So it just depends on the law clerk, Judge Ashley.
Fair.
I love it. Let's get a break. We're going to switch gears. We're going to head back because the lunch break is just... Okay, there you have it. An issue, apparently a bailiff talking to these jurors, and now that individual's not going to be working at the courthouse anymore after today. Michael Jaafar, little bump of the road. Doesn't seem like it was too much, but the judge is going to bring the jurors in and just make sure that everybody's on the same page. Your thoughts, should anything be done here?
I say this purely tongue-in-cheek. We would be a lot better off as a society if we had robots as jurors. Obviously, I mean this tongue-in-cheek. I mean it sarcastically. But jurors are human beings. I think if the jury is not if the jury is not undisturbed and able to analyze a case from beginning to end without distractions, then the whole entire process goes down the tubes. So I think that the judge should be conservative. The judges obviously are always going to lean in favor of conserving a jury and not excusing jurors, and there are jurors who call sick. There's jurors who say I have communication issues, transportation issues, but I think with a case of this magnitude, I think the judge should be conservative, and I think he's doing that.
But I also think that the attorneys are being very reasonable and responsible, and the prosecutor said, no, I don't have to do anything else. I think it's fine. And defense said, well, we could ask the juror just to make sure there's nothing else. I think that at the end of the day, it also goes to attorneys recognizing real life, and maybe somebody said an appropriate, hey, you're in that trial with the kid who killed the mom, and they said, well, those facts were already known. But the attorneys can really drive a lot of this, Michael.
Oh, 100%. Attorneys, they're very important parts of this whole entire process, and the jury has, the whole process. This is an orchestrated symphony, right? It's choreographed. These litigants prepare for months. The jurors prepare for weeks. The judge obviously has been doing this his entire career. So attorneys obviously inform this process tremendously, but at the end of the day, this is an orchestrated symphony. If you ever watch a symphony and you see like one of or any kind of a ballet and one of the dancers trip, the whole entire evening is ruined, right? The whole entire evening is ruined. All you're going to remember is, hey, this dancer tripped. Everybody else did their job the right way. Even that dancer did her job the right way. But if she trips, then the whole entire thing is off kilter. And that's what I liken this to. When you have a jury issue, you're not accustomed to, because we don't see the jury on TV when we're watching it, right? So this whole thing has to fit. And when you blunt momentum like that, it has ramifications.
Yeah.
Mm-hmm. Okay, let's get a break. The judge just talking with those jurors, make sure everything's okay, and then the next witness is going to take the stand, and we'll get you back into the courtroom right after this. Stay with us.
They are queuing up that body cam video. It's perfect time to bring back in Michael Jaafar, still with us. And Michael, it's kind of sad. This is testimony about prior to the killing, the defendant was stating he was going to kill his mom. He was Baker acted, which means he was was restrained, was taken away, put somewhere because of the threats, and yet this still happened at the end of the day. What are your thoughts?
I think the whole thing is tragic because at the end of the day, he had the situation with his father, and then he asked to be Baker acted. He was at a facility, and he asked not to be taken out of the facility. And then with the situation that we're looking at right now, this kid has been crying for help for years, right? It's tragic. I don't know why the defense isn't more in line. I mean, I can see why it's not more in line with, mental health defense, legal insanity, or whatever the case may be. Maybe they think that they have maybe potentially a winning hand with self-defense. But at the end of the day, it's very tragic, and we're watching a very tragic situation of a young man who clearly was troubled in a situation at home. So I think I'm really puzzled as to how this is going. I'm kind of riveted to see how it plays out. But so far, it doesn't look like a very coherent defense, to be honest with you.
Okay. Well, I wonder if he'll take the stand at the end of the day. There's a lot of problems with that. Let's go back in. The audio of this body cam is ready to roll. We're not going to be able to see the body camera in court, but we're going to hear it. So we heard the description of it already from the deputy on the stand. Now let's listen. Michael Jaafar, it seems like there's another example of this is the day before the murder or the killing. This kid was having some major problems, and sadly, this is how it ended. What are your thoughts? You said it earlier. That should the defense be zoning more in a mental health defense, even if they lose it? Post-conviction, he might be in a better spot.
I said that, and as I said it, I thought to myself, those cases, those defenses never, ever have any chance of success. I've been on court TV multiple times saying, look, juries basically nullify the law whenever you say legal insanity. At the end of the day, they've got to take their client at his word. He said that, she fell on a knife. That seems very outlandishly, abnormally unrealistic. But at the end of the day, he does have the situation with the mom. He does have the situation with the dad. He does have the situation with being Baker acted. He did tell multiple authorities, I don't want to go back to the house. It's not going to end well. He has a colorable argument that she maybe attacked him. I don't believe it, but he has a colorable argument that she had attacked him. She had abused him before. Maybe that's the way they're going. If I was a fly on the wall in that room when they were making the decision, Ted, the conversation probably went like this: what do we got to lose? This is what he's saying. He believes it. We can't tell him to lie and say that he did it intentionally when he's telling us that he did it to defend himself. Maybe even in his own mind he was defending it for himself. Maybe we can get him a lesser charge. Maybe we can get it down to manslaughter. Who knows? That's probably how the conversation went. I feel silly I even said that earlier, because at the end of the day, those cases, if I was still taking cases like this, I would tell my client, look, I can't even take your case because of the insanity plea. It's the defense. It's not going to work. So who knows? This is a very difficult case for the defense.
It is, but arguably there's been some domestic violence. I think that mother has had her own issues towards him, and so the self-defense claim, I think potentially, is he going to have to testify if he really wants to put that claim forth, Michael?
Absolutely, 1,000%. No questions asked. He has to testify. No question he has to testify. I always say, listen, if you're on defense for if you're on trial for murder, you don't have to you can't just make everybody else walk the plank. You have to walk the plank. Jurors know that. They're instructed not to put it against you, but jurors are human beings. If you don't testify, if they're going to put it against you, he needs to testify.
Yeah, all right. We are out of time. Stay with us, though. We have more of the deadly son murder trial for Colin Griffith in Florida. Stay with us. Court TV Live.